We are live, and good morning, good afternoon, and good evening to everyone able to join us today with our next Speak Up for Justice program. I'm so thrilled to have this amazing panel of participants in today's program. The first and most important of our group is going to be David Boies, who brings a perspective to the rule of law, unlike really most living American lawyers. And David is our keynote speaker this morning. And David, the question, well, I'm going to have you start off and to go, David.
Okay. Well, look, the rule of law, as we all know, is essential to what we are as a people and what we hope to become. None of the other rights and liberties that we cherish so much are safe without the rule of law. The rule of law has a lot of different definitions, but at a minimum, it requires that the principles that are used to resolve disputes be reasonably predictable and that they be predictable without regard for the identity of the parties. Predictability and an assurance that the identity of their parties will be irrelevant is in turn dependent on the articulation of the principles that are used to make decisions, and then a commitment to follow those principles consistently in future disputes. History, I think, teaches us that the best way to preserve the rule of law is to have an independent judiciary that is committed to the requirements and the limitations that the rule of law imposes, and have a society, including the other branches of government, that are prepared to accept the judiciary's rulings. 25 years ago, Bush v. Gore was emblematic both of what I believe to be a grievous departure from the rule of law, but also of a powerful devotion to the rule of law. The Supreme Court's decision in Bush v. Gore essentially abandoned the rule of law. The court abandoned its procedural and prudential provisions that guided and decided both before and after Bush v. Gore what cases the court would take and how the court would decide cases. It took the case before the votes had actually been counted, before the state court had had an opportunity to resolve any problems with the vote count. It abandoned its principle that we're all familiar with, that you can't argue on appeal things that you haven't argued below. In fact, it permitted the appellants to take a position in the Supreme Court that was directly contrary to the position that they'd taken in the Florida Supreme Court. The equal protection principles that the court articulated as the basis for its decision had never been previously applied by the majority, and indeed was flatly inconsistent with the equal protection jurisprudence of the majority, the five justices of the majority. And they even went so far as to expressly state in the opinion that they were not going to be prepared to follow those principles in subsequent cases. So from looking at the decision itself, it was hardly a model of the rule of law. But interestingly, the commitment of the country at that point in time to the rule of law was so powerful that that opinion was accepted. It was widely criticized by conservative as well as liberal scholars and practitioners. But nobody suggested it wouldn't be followed. No one engaged in personal attacks on the justices. No one threatened them. It was a case where the country came together. I think a majority of the country thought the decision was wrong, but everybody on both sides came together and accepted the decision because, as Al Gore said in his gracious concession speech, this is the way we resolve disputes. And we may think the resolution was wrong, but part of the rule of law is that we accept it.
I think without question, David, the thing that exemplifies the difference between 25 years ago and today is the unwillingness necessarily of people to accept universally the decision that's made by our courts.
I think the key thing for present purposes is first the contrast between 25 years ago and today. In the last 25 years, the attacks, particularly over probably the last 12, 15 years, on judges have been increasingly severe. This is not just criticism of judges' decisions. It's personal attacks on individual judges. It is sometimes threats against the judges. It is sometimes threats to ignore decisions. I mean, more than anything else, we as lawyers know how wrong those attacks are. And more than anyone else, we as lawyers know how those attacks undermine the rule of law by undermining the independent judiciary on which the rule of law depends. We have a particular responsibility, I think, to respond to those. Doesn't mean that criticisms of judicial opinions are out of bounds. It means that these kind of attacks on judges, threats to judges, threats to disregard decisions, are wrong. They're absolutely, irretrievably, irredeemably wrong. We know that, and we've got an obligation, I think, to say that loud, say that proud.
Look, for all that you've done for all these years and for all you've done for each of us, it's such an honor to have you engage with us. This is the first time since April that we have nothing but lawyers addressing the legal community and what we need to do as a community to defend the rule of law and democracy in America today. And Mark Garagos, one of the leading criminal defense attorneys in the United States alive, I want you to talk about due process and how the rule of law really affects American citizens around the country in a way they may not realize the risk. And I want to talk about Judge Frimpong and the federal judge decision from several months ago, where she granted a temporary restraining order in California, the Ninth Circuit area, for requiring ICE officers have due process before they stop, detain, and conduct essentially an arrest. Tell us about that if you can, Mark.
It's an interesting thing. We've got Patty is on with me and lives in Los Angeles as you do, Paul. And Justice Kavanaugh in the Supreme Court mentioned the fact, and I think he probably underestimates it, that Los Angeles, a community of 20 million people, the estimates are is that there's maybe 2 million who are characterized as illegal immigrants. But the reality is, if you live in Los Angeles or work in Los Angeles, is you recognize that the immigrant community is kind of the embedded in the DNA in Los Angeles, literally everywhere and anywhere. And one of the things in the decision you were talking about in the Central District here is that the district court judge issued an order that restrained ICE from coming in here and doing what's been characterized as roving patrols. That went up to the Ninth Circuit, which basically affirmed that decision. And then in what's now affectionately or otherwise called the shadow docket, although in this case it wasn't so much in the shadows because Justice Kavanaugh issued an order, which I just quoted from, basically enjoining the stay and saying that it would probably not succeed on appeal. One of the interesting things about this from a criminal law practitioner is the distinction now about reasonable suspicion versus probable cause. I have argued for years, not I say it jokingly, but it's probably true, is that probable cause has devolved over the years to, in a probable cause proceeding, is my client breathing? And that tends to be probable cause. I hate to be so cynical, but reasonable suspicion is even less, if you will, than probable cause. And if you read what Justice Kavanaugh now defines as reasonable suspicion, even though there is an express disclaimer that that is not ethnicity, everything about that decision is basically ethnicity. And that should scare people. I mean, in this sense, that if you are somebody who does not look basically like me or David or you, Paul, Stephen, I won't go so far as to say you, but you don't live in LA. So the idea that if you look a certain way and you are geographically, and by the way, in LA, that's virtually anywhere, you're in a community, that's reasonable suspicion. That's where we are right now. Why does that make a difference? It makes a difference for a lot of reasons. As I was listening to you and David, the first thing that came to mind is on these threats on the judiciary. We've had a history, an unfortunate history in Los Angeles of judges being murdered. It's happened at least 4 times that I can think of in the last 20 years. However, up until recently, that's always in the family court context. Almost always it's a family court judge. And the litigants, as many people say, when people say, aren't you scared when you do criminal law? I said, no, the place I stay away from is family law. That's where the scariest part of the courthouse is. And that kind of litigant and antagonism and unhinged nature that used to be, at least in my experience, confined to the family law context is now writ large. And that's scary.
Let me get back for just a second, Mark, because I think that a lot of viewers may not really understand what is the shadow docket. What is the emergency docket? Look, doesn't the Supreme Court start the first Monday after October, and in June they're done and they go on vacation? I mean, why are things coming out of the court today when they're supposed to have been on vacation?
So I have a good friend over at in the administration, the Department of Justice, and we have this argument all the time that why should these decisions be made in this fashion? And a shadow docket is basically you don't set it for briefing, you don't set it for oral argument, you don't have the usual kinds of guardrails that you have, you don't let it work up through and kind of do what we as lawyers are used to. You have somebody issue orders a lot of times without any kind of context as to what the reasoning is. And what that ends up doing is nobody understands why, including the district court judges. And there's a raging controversy, for lack of a better characterization, amongst district court judges. How are we supposed to know how we're supposed to rule? And Judge Young, I think, is probably the best example of it. You have people who don't understand why they're getting reversed. My argument and the pushback I get from my friend at the DOJ as well, you don't need that because it's so obvious that the district court has gotten outside of their lane that they don't need a circuit split in order to take it up. It's just they need to be a judicial smackdown or a judicial spank. I think that
traditionally the Supreme Court issues a written decision. A judge can read the decision and know where the boundaries are because the rules are set forth in writing. But when there's just simply an unsigned order, how is a district court judge or anyone going to follow what that unsigned order is suggesting, right, Mark?
Yeah.
That's exactly right. I mean, in this case, you've got Justice Kavanaugh. In this case, when I talk about the roving patrols of ICE, you've got Justice Kavanaugh writing an opinion, and you can see what his reasoning is. And it does, for somebody like me who values the idea of due process and probable cause, it doesn't give you much comfort that we've now reached the point where reasonable suspicion means whatever you want it to mean.
So I guess the question really is, before I move to Patty Glaser, how much concern should Americans have, just general citizens in this country, that there are issues that are being issued by the Supreme Court without guidelines as to how courts are to follow it?
Look, as somebody who's always usually on the receiving end of how do you sleep at night, defending those people. And my response is usually I sleep fine with defending those people. I worry more about the people that I think are innocent. If you are innocent, and I tell the story often, and the parents who come into my office with their kids who've been accused of something, wondering where their rights went, I would invite you to pay attention, because you shouldn't have to get one of your loved ones arrested to realize where we are.
Thank you.
I think it's also worth just remembering that if the courts don't articulate the principles, there's no way of judging. Um, uh, there's no way of predicting, and there's no way of the public knowing what the judges are doing and why. Um, I think Kavanaugh, although I think the opinion was wrong, I don't think you can possibly defend it on the grounds that it's anything other than authenticity. Um, I think he deserves respect for being prepared to articulate what those principles were. The rule of law requires that the principles of decision be articulated, in part so that we know what the law is going to be, and in part so we can judge whether it's going to be consistently enforced, and in part so that we can criticize the opinion. You
David,
don't
I
have to
agree
get any of that.
wholeheartedly. I
Paul,
agree
nobody,
wholeheartedly.
nobody can disagree with David or Mark in principle, but I'd like to go back earlier in the process, and predictability is, of course, the most important thing with rule of law in a democracy. Are you going to convince people who are desperately interested in healthcare and putting food on their table that that's the most important issue of the day? No, you're not going to convince them. We need to do other things that we haven't thought of yet to have this discussion, and lawyers need to lead the way. But I will say this, part of the process, and everybody can disagree, is I can remember when Kavanaugh and Aliota were up before the Senate. They could not have been treated with more abuse. And that process, and I wouldn't have approved either one of them. Having said that, the process, the brutal process they had to go through is emblematic, if we want to use that word, emblematic of where we are in this country. People aren't listening to each other. And it's very, very frustrating.
Patty, the word stare decisis means nothing to most Americans. But in the confirmation hearing of all these justices, they said they follow stare decisis, which is predictability. And we today ignore it completely, and how we can't.
Stephen, they were attacked personally as well.
Well, they were. There's no question.
No.
But they also made a commitment to follow stare decisis, which they have totally ignored.
I'm not approving them. I'm just saying that the brutality of the Congress, who needed to show off for whatever their constituency may be, was really hurtful to the process, in my judgment.
I agree with Patty. I think that the brutalization of the confirmation process, and the political attacks that start right then, I think is part of the problem, and I think that human nature being what it is, I think that process can radicalize people.
David and Paul, I guess, and Mark as well. There's a wonderful play that Arthur Miller wrote years and years ago that we recently had a staged reading of, called Incident at Vichy.
Oh, yes, I know.
If you go to read that play or see it, it is so clear that it's a predictor of where we are today, where people are just, in this case, Jews, just taken off the street.
Yeah.
Put through a process and then gassed.
Mm-hmm.
So we are, the old thing about you're bound to continue to make mistakes if you're not paying attention to history. That could not be truer. And that play is very, very parallel to where we are today, whether it's alleged illegal immigrants or whatever. It's scary, and informed people shouldn't be scared. They should be motivated.
Just by way of introduction, Patty Glaser is a remarkable lawyer based in California. She represents a lot of significant individuals and non. She's got David Geffen and Sony Pictures and Walt Disney and Kirk Kerkorian. And I really wanted Patty to address the stare decisis. For those that don't understand, that means you follow the decisions that have come before you. Assuming they were well reasoned 100 years ago, no reason why they shouldn't stay in place today. Why is stare decisis important for you and your clients, Patty?
That's an easy one. I think somebody else mentioned it before. Predictability is everything in business, and in the law business. And if you don't have predictability, you just flounder. So what we're looking for, and I say this half jokingly, in America, there's hopefully still the rule of law, and then there's a particular state that happens to be in the South that is completely divorced from any sort of predictability whatsoever. Depends on the judge, depends on the day, etc. That is a place where I try to stay out of litigation. But I can go to Georgia, I can go to Illinois, I can go to California, I can go to New York. It's predictable. You may not like the decision, but it's predictable, and that is everything to anybody that has to engage in the legal system.
And look, that brings us to Steve Zack. And Steve, former president of the American Bar Association, a CV that is so long it's difficult to even address. But what was interesting in looking and listening to David's remarks and Mark's remarks, Steve, is you have your own personal experience with risks of the rule of law and your role in this country. So if you don't mind, tell our viewers a little bit about your own background.
Well, actually, I experienced it directly as a 14-year-old in Cuba. My mother's Cuban. We lived in Cuba. We were American citizens. She was naturalized, and we were taken off a plane and put under house arrest, and not sure whether we'd see the family again. And we felt that there was no one there to help us. There was no rule of law. So actually, that's, I think, what motivated me at the beginning to become a lawyer. But when to follow up on David in Bush versus Gore, I had the privilege of being and have the privilege of being David's partner and tried the case with him. But right afterwards, I went to China to address the Chinese Lawyers Association in a large group, and a young man stood up and said, "How did you feel, Mr. Zack, about losing?" Took the word losing forever. Bush versus Gore, and everybody was waiting for my answer, and it wasn't that difficult a question actually for me. Well, I know that from that I learned that in the United States we turn to our lawyers and not to our generals, and that is the difference in most countries. I chaired the ROLI, which Rule of Law Initiative of the American Bar, which Steve Breyer now chairs, which has 42 countries under its wing. And the main difference in most of those countries, again, is that the rule of law does not apply. It's the rule of the king. You know, when you walk through the columns of the Supreme Court of the United States, there's a sign above it. You ought to look at it. I'm sure you have. And it says, justice under the rule of law, not the rule of kings, justice under the rule of law. And that's what we hope to regain or at least retain. Now, the ABA is very active in this area, and we have filed a complaint, 57-page complaint, which I don't think I have the time to discuss in detail, but that I'm happy to provide anybody with, that talks about Wilmer Hale, talks about Jennifer Block, talks about Paul Weiss, a number of firms, and what has happened to them.
By the way, those were firms that bent a knee to the administration and gave in to the executive orders, right?
That is correct, but it's also what is described by the administration as the intimidation policy. Actually, this is just not an accident, and this is not based on just one law firm. This is a policy of intimidation to intimidate lawyers, to intimidate judges, and to intimidate the use of the Constitution to defend your rights. And a matter of fact,
Stephen, let me just ask you a question, though. I'm interrupting you, and I apologize.
sure. No, please.
There's been precedent for doing this on the left, as well as the right, and everybody is up in arms with the right and the so-called king. But what we are forgetting is guys like Douglas, when he was on the Supreme Court, he'd go off on some sort of tangent just because he needed to get to the particular end without any solid reasoning at all. Nobody complained, nobody talked about the king then. I just think that we need to have a balanced Republican, Democrat, right, left.
Absolutely correct. But let me give you an example of how that has occurred in the past. When FDR tried to pack the court, the ABA came out against that, okay? Clearly against that. So this is not left or right. And I know that there are people who think that the ABA is on the left. Some people are telling me it's not enough on the right. I mean, or too much on the right even. The fact is, where you stand depends on where you sit, which is my favorite quote from Will Rogers. And today, you can't even have a reasoned conversation with people until you decide where they sit. Now, this complaint is well done. It asks for a declaration of relief in the security clearance termination provision, in the government contracting provision, in the federal building and employee access provision, the federal employment additional provisions on that. Anyway, we have asked for relief against a number of agencies. Where this ends, I'm not sure. I am not particularly optimistic about it. As my doctors would say, I'm a little guardedly optimistic, but I'm hoping that the rule of law will prevail. Now, the ABA is the largest voluntary lawyer association in the world. However, we have so many people supporting us. We have the Canadian Bar, we have ABOTA, we have International Academy of Trial Lawyers, we have Australia, we have hundreds of law associations and bar associations around the world and country standing with us. And we have to stand together. And we have to not cower to the king, which is what has happened so far. And it's understandable. I mean, the head of one of those law firms, I'm not going to name, said that they were destroying their business and they had to do it to protect their business. Well, there's more things in life than business.
And they didn't have to do it to defend their business. A lot of firms have said no, and their businesses are doing just fine.
And they said they were being attacked by other law firms, and it was ridiculous. The truth of the matter is that lawyers in that firm, many of whom I know, have left firms because they have kowtowed to the president. So, we are at the beginning of a battle, and that's why we're here today to discuss how we're going to proceed in that battle.
To put this in perspective, Steve,
And I'd like to, can I just emphasize one thing that Patty said?
Sure.
And that is that I think it's critically important that this not be viewed as a left, right, or Republican, Democrat issue. This is an issue that everybody who cares about this country, everybody who cares about the rule of law ought to care about. And I don't always agree. Maybe I don't even mostly agree with Senator Cruz. But I thought Senator Cruz's comments recently were really on point, where he was saying, I agree with some of the objectives here. I think people have gone, in his view, too far to the left. But he says this isn't the right way to do it, because sometime the shoe is going to be on the other foot. Sometime you're going to have a left oriented party in charge of the presidency in both houses of Congress. And then we're going to need to depend on the courts to protect our rights. And this is something that it is too easy when you agree with the objectives of the party in power to be tolerant of these kind of abuses.
David, isn't the critical issue? How do you get across to the population who's voting?
Yeah.
How do you get across to them that this is our democracy is at risk I don't know how to do that, and
You
I
got to
haven't.
explain to them
That's a good
how,
segue,
you got to
Paul.
explain to them how it affects them. You have to explain how it affects them personally.
And
And
so let me do this, Steve. Let me introduce Lauren Rikleen. Stiller Rikleen is head of Lawyers Defending American Democracy. There are 1.3 million lawyers in America because we're a rule of law society. We need that. Lauren, tell us about what's happening.
Thank you. I appreciate the opportunity. So Lawyers Defending American Democracy was created 6 years ago as a nonpartisan organization to respond then to this critical question: where's the voice of the legal profession when the fundamental values of this country are under attack? And at that time in 2019, LDAT identified core values and principles that were being undermined, including the rule of law, institutional checks and balances, separation of powers, press freedoms, truthfulness to the public, and the integrity of our system of justice. I suspect these all sound familiar today. And we detailed then exactly what the violations of those principles were and why they mattered. And the concept of why these abuses mattered is the through line to our work today and this conversation that we're having. We seek accountability for lawyers, for example, who violate their oath and their obligations to the profession's rules of ethics. Why? Because our entire justice system is based on lawyers following those rules and standing before judges with the law as their guide, not their boss or their president. We file amicus briefs to aid the court in understanding why this case before them matters to the country and the health of our democracy. We undertake special research and writing projects to demonstrate, for example, why it matters to the lives of all of us that the executive edicts that have been issued in the past 10 months are directly tied to the autocratic playbook, Project 2025. And now we're launching a new initiative that's called Meeting the Moment, a call for lawyers to lead. And this initiative is based on an essential premise. There's an urgent need for every American to understand that the issues we are addressing, rule of law, democracy, the justice system, affect every one of us. And we believe that lawyers are the trusted voices in their communities with special training and communication skills who can and must be leaders to help both their colleagues and the public understand why they cannot stay silent now. So together we're developing and promoting key messages to respond to the very overly fast-paced news cycles filled with disinformation that are undermining our constitutional values. We have talented volunteer lawyers working every day to inspire people to understand that none of us can be bystanders to the dismantling of our government, the tearing down of our constitutional system, the threats to our judges, and the constant contempt for the norms and the principles that had been strengthening for 250 years. So I'm grateful to be part of this webinar with all of you, and I hope that people who are watching will leave inspired to use their own voices to explain why we must all be participants in addressing this challenge of our lifetime.
Lauren, that's an amazing summary in a very short period of time on a very complex issue. But it really brings us then to Traci Feit, because that's Lawyers for Good Government. So, Traci, what's Lawyers for Good Government doing?
Thank you so much, Paul. And what an honor to be on this panel. Is it okay if I quickly show my screen? It won't take long.
See, I'll let you know.
All right.
No, it's
So,
working.
yeah. So my name is Traci Feit. I'm the founder and president of Lawyers for Good Government. L4GG was born the night of the 2016 election when I posted a call to action on Facebook. Within 3 weeks, more than 10% of the nation's lawyers, about 125,000 lawyers, advocates across the country, had joined the group that would become our organization. Today, we're a national nonprofit with a team of more than 45 staff across 18 states. We work with a network of more than 150 law firms, and we also work with tens of thousands of individual lawyers across the country. Over that time, we have lived our mission, which is to mobilize lawyers, mostly to do pro bono work. But in our view, that also includes advocacy. So over our about 9 years, by the end of this year, we'll be at, I think, about $150 million in pro bono legal services mobilized. So we firmly believe that lawyers have both the capability and the moral and ethical responsibility to help save our country. Now, how we do that is we try to shift the balance by ensuring that the legal community shows up strategically, visibly, and together. That way we can protect what matters, and that's what L4GG was built for. We identify where lawyers can make the most impact, we try to remove the barriers that keep them from engaging, and we design rapid response programs to mobilize legal talent at scale. So very quickly, the work we're doing today, which is, we think, both urgent and scalable, first is in the area of democracy and the rule of law. We all know democratic systems don't defend themselves. That's our job as lawyers. And that's why we're focused on building a visible and coordinated legal response. A few examples. Our pro bono litigation core, which we created when we recognized that there was going to be a shortage of, in many law firms, either being unwilling or unable to engage in litigation against the perceived interests of the federal government. Through the pro bono litigation core, we are activating seasoned litigators, individuals who may not already be working through a law firm or through an existing organization, many unaffiliated or recently retired, to work with our staff litigators to join high-impact constitutional and civil rights cases. We also run campaigns, like we helped to co-lead the National Law Day of Action when 10,000 lawyers showed up in more than 50 cities to publicly reaffirm our oaths to defend the Constitution and the rule of law. And we also believe that a thriving civil society is essential to democratic governance. That's why our Fund Protection Clinic is offering nonprofit organizations facing unconstitutional attacks on democratically approved federal funding one-to-one pro bono attorney consultations on grant compliance, administrative procedures, and defending against improper terminations. I'm going to skip past these other slides that my team so thoughtfully put together because I know the focus of today is not our work on climate or civil rights or health equity, but anyone interested in those issues, please do check out our website, and I'll skip ahead to how to work with us. You can go to l4gg.org/volunteer to get involved. You can also join our text rapid response list. All you have to do is send a text, any text, to 771-203-4895. And I'll leave the rest on the screen so I don't bore anyone. But thank you again, Paul, for creating this opportunity for us to share these opportunities. And thanks to everyone listening.
Can I ask you a quick question? The overarching message from the government is don't exercise your constitutional rights or we're coming after you. All right?
Yes.
And how are you dealing with that issue?
Well, the first thing that we're trying to do in response to that is lead with courage. Many organizations that we partner with, and in fact, our organization itself has already come under attack or has already been told that we're under investigation. Things are being announced every day to make the situation worse. Funding is being affected. And so the first thing we're doing is continuing to stand and to fight and to stand with those who are being attacked. We are also trying to make sure that those who want to defend their constitutional and civil rights have lawyers to do so. That's part of the reason behind the pro bono litigation core. There are so many people and so many communities in need of representation right now. And we need to make sure that every lawyer who has the skills and who has the capabilities to make a difference in that fight has the administrative support and the logistical support to be able to help defend those individuals.
Hey, Chris, let me have you pull down the screen share
Of
sec
course,
so we
yeah.
can go back to full screen.
Yes, sorry, it's taking me a second to get there, but I will. Go ahead.
No, there we go. And I'm going to pull us into gallery view because what I really want to do is kind of get back to Patty's idea of what do we do to pull ourselves together as a nation, as a people, to get people engaged, to understand that if you're not a white American, you are at risk of suspicion and being detained. And while Judge Kavanaugh says the detention period should be pretty brief, I assure you, if you're in custody for 2 or 3 hours without access to a lawyer, it feels like a lifetime, right, Mark?
Exactly right. And like I say, unfortunately, it doesn't seem to really resonate with people until it happens to them or someone close to them. Los Angeles, I'll return to what I said before. The community is so entrenched. The fabric of the community is so impacted by the things that are happening with ICE that you have people who don't want to leave their house. You have people who don't want to go to work. You have people who literally are scared out of their mind. And that
but
has
Mark, you have to at least deal with an issue that is raised by everybody who has this. Your issue is right, of course. Having said that, the fact that there are the biggest argument I've ever heard from people who don't agree with you is the fact that there is a tremendous amount of extra cost for healthcare in California, using California as an example, huge amount because of the number of illegal immigrants who come into this country and get healthcare. And that cost is what people complain about. So when I hear Traci and I hear Lauren talk about highfalutin, ideas, it's all great, but when it comes down to it, it's how are people gonna live? And who's gonna pay for the health care
I have
for
to
all
say,
the immigrants?
yeah, I have to say, I object to the notion that protecting democracy and defending the rule of law would be considered highfalutin. I can't believe that every single person in this country doesn't believe in due process once there's conversation so that there's a full understanding of what that is. And the notion that any of this is partisan is kind of beyond me at this point. We are living through unprecedented times. We are seeing things happening in the destruction of our government and our democracy that has never been seen at this scale, and certainly in our lifetimes in this country. And probably we might have to go. We'll watch the Ken Burns documentary and see what he has to say. But we can't. It's not an either or. We need to have affordable health care in this country for sure. But we also need to have a rule of law that applies to all of us. They're just all these things matter.
Agreed. These have to be two separate issues.
You're exactly right. But having experienced being taken from your family, put in a jail cell overnight.
Absolutely.
Kavanaugh talks about a brief period of time. Let me tell you, those were the hardest 24 hours of my life, not knowing whether I'd ever see my family again, whether I'd be alive in the morning.
Of course.
That is not insignificant to any person who has to go through it. My Cuban friends who voted for this administration, I asked them clearly, how do you like the fact that your grandma is going back to Cuba? Because that's what's happening now. And there are all kinds of people who are realizing what sounded good. Oh, we're going to help the healthcare system. We're not going to pay for people. We're not supposed. When it affects them, it's not so good, and it hurts. And there's no way to get around it if we don't do something about it. Now, the problem is, Alex de Tocqueville, when he looked at America, said, what makes us different than the rest of the world? It was the legal system, was the rule of law, okay? John Quincy Adams felt that way defending the British. However, today, I had the privilege of being the United States delegate to the United Nations. They think the rule of law is an imperial doctrine, okay? They don't have any respect for it. That's not how their governments work. You're out of office, you're going to jail. Look at Sarkozy. He went to jail yesterday. Okay? You're going to have the next person go to jail, whoever is going to be the next person in office. Well, the worm is going to turn one day, and then the enemies of that particular president is going to be in the same situation as other countries around the world, that they're going to be the targets for abuse, which is what we're seeing today.
I just have to add one thing to this, which is, and I can't let this go, I'm sorry, but even if we thought that certain benefits should or should not go to a group of people, I can't believe anyone would argue the solution is to round up the people who are benefiting from those things and cart them away without due process. That's a political issue. We can vote on that. We can make law about that, but that's totally separate from how to handle individuals who are benefiting from that process. Due process is a right.
True, Traci.
I think that's
absolutely true, but you still have to get your message across. And when you talk about constitutional issues, I'm saying to you, most people don't focus on constitutional issues or threats to the democracy. What they focus on is healthcare and food on their table for their families. And you, who's doing a great job, and you, Lauren, who's doing a great job, need to figure out a way and get as much help as you think is appropriate to communicate with people about the significance of these issues. That's all I'm saying.
I would agree. We can always use improvement on messaging.
Look, the fact is messaging is
we're going into high schools now, and we're talking about First Amendment rights. We say, what the heck is that, right? What's the First Amendment right? Well, we say, how about if we have your parents go into your room and look around and take anything they think is abusive and put you under surveillance for the next 30 days. They understand that. They understand how it affects them. So we have to bring it down to the basic level that will be appreciated by the people who we're going to rely on, and that's the future of our country. And when the ABA
funny you say that, Stephen. This guy looking over my shoulder, that's how he got us out of bed on Saturday morning. He used to come in and search my room and my brother's room at 7 a.m. We would hop out of bed immediately because that was a violation of our Fourth Amendment right.
You survived pretty well.
That's Mark's father looking over his shoulder, just so you know that person.
Exactly.
So let me say this, folks. We could literally spend the day having this discussion because it's such an important dialogue. But on the one hand, we need Traci, we need Lauren, we need the lawyers to get engaged, and we need to speak up for our justice system. It's the lawyers who need to step out and do that for our courts and for our democracy. On the other hand, Patty, you make an amazing point. We need to better the message to individuals to understand how this affects them, whether it's your clients or it's the individuals that Mark represents who are put away.
Well,
and don't have
all due respect, it's more than the lawyers. When we are attacked in Florida on malpractice, things like that, we don't have the lawyers speaking because the public sees the lawyers as people who are just in it for the money, okay? They're benefiting from the rule of law. We need average Americans talking about how it affects their lives every single day, not to protect the Constitution. The Constitution isn't for the lawyers. It's for all Americans.
True. And what I want to do is go back to what you just said a moment ago. We need to do a better job of educating our students to appreciate the importance of democracy in America today, understanding what our constitutional framework is, because until they understand what it is, they don't feel the need to protect it. And so what the ABA is doing now and stepping up in a nonpartisan way is critical. David, the work you've done for decades for the system is incredible. And Mark, what you do to protect the interests of those who have been accused is remarkable. Patty, your work with the clients you represent and your passion is remarkable. And Lauren and Traci, your efforts to keep the legal community engaged and these services going forward is essential to what we have going forward as a group. I want to thank everyone for participating today. This is an ongoing dialogue. And again, my thanks to the entire team. And we're done. Thanks all.